another one.
Okay.
And apparently there's a third set that we still don't have. That they're still working.
Right. Because could somebody explain to the court, why is it the day of trial, a jury selected, and all of a sudden there are CPS records that are discovered? When I will tell you, when I was practicing, and I know people say, Stephanie, stop saying when you were practicing. But when I was practicing, here's a hint, if there's assault of a child, guess what? There's probably going to be CPS records if that's the boyfriend, husband, or somebody living in the home. If there's a case involving a child abuse, somebody hits a child, somebody spanks a child, whatever, if there's an injury to a child, there's going to be a CPS record. Either it's going to be CPS goes out and they just say, everything's great. The danger has been removed, which means the person who's alleged to have committed the offense is in custody. Why are we always here at the last minute with CPS records when everybody should know that there are CPS records in a family violence case? And I take time and discovery compliance. We had a discovery compliance on this case, October 20th, 2022.
Just for the record, I did not represent him at that time.
Yeah.
I came on just a few months ago.
Right. So I guess now, in every case, I'm going to take it upon myself to say, is there CPS records? And I'm going to have to send everybody out to do some research to find if there are CPS records, because we had a jury here that said we're going to start at 9:30 and it's almost 11 and we haven't started because we don't have CPS records. CPS records have just been turned over. We don't have somebody's on probation and we don't have their conditions of probation, which I think Bashan, and this is not even her case, and the person is not even on probation with her, but it's all hands on deck and she's pulling records that should have already been done before we start trial. So what we're going to do is, my understanding off the record, everybody said, there may be a different offer that was never made before. So I gave everybody 5 minutes. So if there's going to be an offer that has never been made before, then that needs to be told to the court now. Because otherwise, what's going to happen is we are doing this outcry. The jury is going to be allowed to get several witnesses in because they've been here since 9:30. And everybody is getting 2 minutes for opening statements. 2.
Your Honor,
Yes.
if I may, for the probation records, I've provided the conditions and any amended conditions that were in your file. As far as the original conditions where it states the attachments are simply the referrals for the parenting class, all of the vendors that we have. There's that. It's just the list of the vendors.
Okay. All right. Thank you. So defense? Well, John, you're aware of what probation has just stated.
Yes.
So there is no attachments of other conditions.
Judge, we're going to enter a plea bargain. It's going to be an 18-month state jail sentence.
All right. I will consider that once I see the police report so I can know exactly what this case is about.
Okay. Again, so they're going to work on the paperwork right now.
All right. And we're off the record. John, this is where I remember I'm not going to mention the judge's name, but there was a case and I was just sitting in the gallery, not a part of the case or anything. The defense attorney was, Stephanie, will you just sit and, take notes or something for me? I'm like, okay. I wasn't even sitting at the table. I'm just in the gallery taking notes. And the judge granted a motion in limine on something. And I know that sometimes when somebody says over and over, remember the motion in limine, remembering the motion in limine, it's just in your head and all of a sudden you're violating the motion in limine, right? So this attorney, after they had said it over and over and over again, and Rita Spiegel was the prosecutor, and they took, 2-minute break. I told the attorney, I said, I know everybody has been saying, remember the motion in limine, remember the motion in limine. I said, but you should probably write that down because I know what happens when somebody keeps saying something and over and over. It's like the movie, The Children of the Dam, when they say, don't think about the brick wall and everybody's crashing in the brick wall. So you should watch Children of the Dam. It's from I think it was a 1960 movie. So anyway, I write him a note. He's looking at the note. He's like, again, I'm just in the gallery. I'm not even at the table. He violates the motion in limine. The judge sends the jury out, and then the judge says, and Stephanie Boyd, don't leave. It's not my trial. And the judge says, I want everybody in my chambers now. And I go back there and you're not to leave. And I'm like, and it was funny because I think I had maybe been out practicing for 5 years. And I want to say, excuse me, this is not my case. I'm not listed on any of the paperwork. I'm just, sitting in the back in the gallery, not at the table. I wasn't even on the bench that's directly behind the attorney.
And you got right.
Yes. And I said, okay. And then I stayed for the entire trial.
That is hilarious.
Yeah, but that's funny. Oh. Can you mute us, please? Can I have the parties on Raul Reyes? Court is calling 2022 CR 4920, State of Texas versus Raul Reyes. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Megan Enriquez and John Coons for Raul Reyes.
Are you Mr. Reyes?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I believe I have received all the discovery that is currently in the state's possession, Your Honor, and I have reviewed it with my client.
All right, the court will find that the state is in compliance with discovery. Mr. Reyes, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving the enhancement paragraphs and proceeding on count one. I'm sorry. Lesser included reckless injury to a child. Yeah.
Any objection?
No, Your Honor, that's our understanding.
Showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Did you understand that the state is proceeding on the lesser included offense of injury to a child reckless? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
Did you intend to give up those rights and enter into a plea in this case?
Yes, I do.
Counsel, has your client been able to provide you with any defenses?
Yes, he has lots of defenses.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent, was legally sane at the time of the offense?
I believe he is currently competent and was legally seen at the time of the offense.
Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, I did.
According to the plea, state is proceeding on the lesser included offense of injury to a child, bodily injury, reckless. They're asking that your punishment be assessed at 18 months in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed and heard by the court. Did you understand?
Yes, ma'am.
And ruled upon. Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense of injury to a child reckless, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all of its attachments.
No objection, Your Honor.
Join you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sure.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, and
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, I'm thankful to my client for trusting me with his case, and I'm thankful to the state throughout our conferring and negotiations. And we just respectfully ask the court to follow this plea of bargain agreement that we've reached with the state.
All right.
And also that we also respectfully ask the court to grant him credit for all the time he has served in custody. I believe he has approximately, I think it's 216 days in the Bexar County Jail.
Okay. All right. And the court normally does not accept plea bargain agreements without good cause, or you have to plead open to the court. The court is going to find that there is good cause to accept this plea bargain agreement based upon the discussions that the court has had with the defense and the state, both being present, and Mr. Reyes being present. All right, Mr. Reyes, is there anything you wish to say before the court passes judgment?
I know. I just want to thank my attorneys for really helping me with this case, and just for giving me the chance to accept the plea bargain also.
All right. And what have you learned from this incident?
Not to lay down with dogs, because you will get these.
But see, here's the thing. When you say not to lay down with dogs, the only people who lay down with dogs are dogs.
That's exactly what I mean, ma'am.
So you're not
going to be a dog anymore, and I'm going to stay away from other dogs. And I think I'm going to stay away from a lot of people when I get out, you know.
Let me tell you what you should have learned from this incident, from my reading this. Number one, you're an adult. This is a child. You can't play games with children that involve physical contact. There's a reason why when you see football games, they don't have young children playing with grown people. That's why you got the Pop Warner League, because those little children should not be playing football with adults. So in this case, it appears that you all were playing some sort of TikTok thing. And then this child hits you on the back of the head with talcum powder. And then you hit him and he hits a wall. You can't be playing violent games with children of this nature. You understand? That's what you should learn from this.
Yes, sir.
I was considering giving you less than 18 months, but I don't know if he's learned much from the statements he's made to the court. So I'm going to find you guilty.
Well, Judge,
Yes.
obviously.
All right.
Yeah,
John's coming
please.
in.
If you've opened that door a little bit, I, from our perspective, well, we've only known Raul for a few months now. He's made some mistakes in life, obviously, and he put himself in a bad situation. He definitely has learned from this situation. He is not someone that
Never been violent with.
This was an accident, quite frankly, from his perspective in terms of what happened. And when the police arrived at the scene, the mother immediately tells the police officer that her son was fine. She says he's okay. She says it several times. The kid had essentially no injuries. There's maybe even a tiny little bruise, but even that in the photos that were provided to us, you can't see anything. I think I understand that you might not be particularly happy with what Raul or how he just replied to you, but I do think his mother's been here for many of his court settings. She's a very nice woman. I know she raised him better than this, and he's unfortunately kind of made some bad choices in life, but his father's in failing health. He has a sister who has some health problems too. If there's any chance that you could show him any additional mercy, that would be wonderful.
All right. And then John Kuntz, you stepped in, and now Brittany Mitchell stepping in.
Yes, Your Honor, and it's not for a reason you might think. I've been discussing with the mother of the victim. As the court knows, she is on probation. She wanted it to be known she's not here voluntarily. She is begging for me to drop the charges right now. And I told her that I would come and represent that to the court. But based on his history, the state feels that the 18 months is fair.
Okay. All right. Thank you so much.
Well,
you,
and yeah, briefly, Your Honor, I wasn't aware of that. And in light of that too, we'd ask that he get time served based on the time that he has served.
All right. Could I see the mother just briefly? Is she here?
Yes, Your Honor.
You just step to the side. Does anyone know where she is? Is she upstairs? Is she missing? Has she left the building? Just wondering.
Having been an advocate for how many years? Yeah, you've been there. You know.
Outside voice, you know. Sorry. Judge.
All right. Hasn't she been subpoenaed?
Was she subpoenaed, Travis?
So I think she was always telling us she would come, so I don't think we ever.
All right, well, tell them she needs to come into court. Yes, please.
I can go get her. Okay, we'll do that.
Thank you.
People with guns here, they can go get her.
No, we're not going to do that. Hello. All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand. State your name for the record.
Sylvia Martinez Lopez.
All right. Now, I understand that you are on probation, so no one is going to ask you anything that will put you in any type of legal jeopardy. You understand?
Yes, ma'am.
All right. So I want to make something clear to you, and I want you to listen to me very clearly. And that's why I wanted you in here, and it's on the record. So with regards to any CPS case you have open, this is going to be on the record and anybody will be able to get it. Do you understand?
Yes.
This gentleman over here to my right, Mr. Reyes, you are not to have any contact with him. Do you understand?
Yes.
He is not to have any contact with the complainant in this case, which is your child. Do you understand?
Yes.
Now, I've read the police reports, and I know in the police report, you put in there, oh, I barely knew him. You and I both know that's not true. You are not to have contact with him. If he ends up at your house, whether he shows up on his own, if he does, you need to call the police. Or if he shows up because you've invited him into your house, Child Protective Services is going to know about it. Do you understand?
Yes, ma'am.
How old is your child?
11.
How many children do you have?
4.
What are their ages?
18, 17, 16.
Do they all live with you?
Yes, ma'am.
Right. And Child Protective Services is in your life, right?
No, ma'am.
Right. They're going to be in your life if you don't get your act together.
Yes.
And I know they were in your life previously.
Yes, ma'am.
I get so many parents when I was a defense attorney. You know what they would tell me when I would represent them in their CPS cases? They say, I'll walk through fire for my children. And you know what I would tell them? You don't need to walk through fire for your children. Nobody's asking you to do that. But what you have to do is you cannot be bringing people in their lives who should not be in their life.
Yes, ma'am.
People with criminal histories shouldn't be in your children's life because you're trying to set an example for them. And you know what they would tell me every time? Okay, Stephanie, I'll do what you say. I'm not going to get a new boyfriend. I'm not going to get pregnant during the pendency of this case because I want my children back and I'll do whatever I can to get my children back. And guess what they did? I would get their children back for them. You'd have this probationary period with CPS where they're still in your life. Next thing I know, I'm getting a call from the caseworker. And you know what they're telling me? Stephanie, your client is pregnant and she's moved some guy in here that she's met at the club on Friday and they don't leave. So, do you understand my instructions?
That's fine.
And I've read the police report. In the police report, it states that you said that your child did not suffer any major injury. Is that true?
Yes, ma'am.
And how is your child doing now?
He's doing good.
All right. And why are you letting them play this stupid game where they're putting talcum powder and he's hitting this gentleman on the back of the head. Why were you allowing that in your house?
I didn't know my son was gonna do that.
Hmm.
I didn't know.
You should not be allowing that. There is a reason. And while you were out, I told everybody this, there is a reason why you don't have children playing sports with adults, because they can get injured. You don't see Pop Warner football team playing college players. You know why? Because they can get injured. Your children need to behave as children behave, and you shouldn't bring anybody in your house who's going to roughhouse them and hurt them in that way. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
Are they, so in other words, he is getting,
No, in other words,
because I mean, I wanted
Here's the
to drop the
the charges are not getting dropped.
Mhm.
What you should be concentrating on is, instead of what's happening to him, you need to start putting your children first, and you're not.
No, I do put my children.
No, you do
first.
not.
Okay, ma'am.
Let me ask you this. If you put your children first, why are you letting somebody with his history come live at your house?
He wasn't living at my house.
Mhm.
No, he
But you
wasn't.
knew him, didn't you?
Yes, I did.
And
I
you
knew
told
him,
the
I met him
police
through
you
the mall.
barely knew him.
I met him
That's
through
what's
the
in the
mall.
police report.
Okay.
You're not putting your children first. And if you don't put your children first, you know what's going to end up happening? You're going to have another CPS case, and you're going to have somebody else looking after your children, and who knows what will happen. Do you understand?
Yes, ma'am.
Any questions from anybody else?
Not from the state, Your Honor.
Nothing from the defense, Judge.
All right.
finding
You're
you
guilty. I'm going to
excused.
sentence you to 13 months in the state jail facility, give you credit for any time served. There's to be no contact with us and Sylvia Lopez. Do you understand?
Yes, ma'am.
And it would probably be in your best interest. Do not get involved with people who have children until you have your life in order. Do you understand?
Yes, ma'am. I understand.
And you're an adult. You should know better than to start playing these type of games with a young child. You understand?
Yes, ma'am.
And it is never appropriate in the situation that you were in to discipline somebody in anger, because it sounds like you were angry because he put talcum powder on his hand and then hit you at the back of the head. So that's not appropriate. You understand?
Can I say one thing, Your Honor?
No, no.
I'm sorry. No, I wasn't.
There's a lot of no's going on from your counsel. I think it would probably be best for you to listen to them, because they went to law school, and there's a reason they're telling you no. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
And I see there's a previous affirmative finding of family violence. With that, you're not allowed to own any weapons or ammunition. Do you understand?
Yes, ma'am.
All right. Good luck to you.
Thank you. Your Honor.
Thank you very
Welcome.
much, Judge.
All right. And attorneys, please remain. And Deputy Laura, when you get a chance, if you could bring the jurors in. So, ladies and gentlemen, I want to thank you so much for your service. I was not able to select the jury because we were in a jury trial already. So that's why Judge Nahara was doing jury selection. So we were going to have the jury trial today on Mr. Reyes. I know I instructed everyone to be here at 9:30, but there were some issues that we had come up. But I want you to know that your time was not wasted on your being here, because actually both the state and the defense were able to come to an agreement on this case that I approved of. So I thought to myself, do I let them continue to wait in the back and perhaps you will be done with your service for today? Or do I send you home and bring you back? So I thought that maybe you all would be okay with us keeping you in the back, maybe extra time, and then you will be done with your duty for today. So I hope I made the right choice for everybody. We do a lot of cases in this court. They're all felony cases. The attorneys on each side are very good attorneys. And so they were able to work things out. You're always welcome in the 187 District Court. We're here every day, and every day we do have a huge docket. I always, though, try to make sure that you know that your time is valuable and that we're not purposely having you come in at a specific time, then keeping you waiting. All right. Is there any questions from anyone? All right. So I want you to know there is a shortage of court reporters. I always tell jurors this, but there is an introductory course at St. Philip's College. So if you have someone who's just graduated high school and they want to take a gap year or find themselves, tell them to find themselves at St. Philip's College and they could potentially become a court reporter. Court reporters are paid very well. I have 3 degrees and the court reporter makes more than I do. So I put that out there because whenever I have the court reporter talk about it, they don't sell it very well. And people are just like, I don't want to do that. But it is a very lucrative career. And if maybe you're at home and you're thinking, heck, I could be in the legal field, but I really don't want to go to law school, or I want to do something different. I just want to listen and see what's going on. You too can be a court reporter. And whether or not you're a court reporter quickly or not so quickly really depends on your speed and accuracy. How many words do they have to get right, Deputy Laura?
255.
255. 275. Now, when I was growing up, we only had typewriters. And I started out on a manual typewriter. The young people know, John, you may know about manual typewriters. The young people don't know.
Yes, yes.
You know, thank you. Flipping that return carriage. And I really thought I was doing something when I would do the double space because you got a chance to hit it quick like you were going faster. And then we finally got the electric typewriters. But in my heyday, I could do probably 175 words a minute with no mistakes. So the fact that on this, you have to do 275 words and they tell me you're not typing the entire word. So I think people will be able to do that. The machines, though, are very expensive. They cost about $10,000, but the court reporters, if you call them, they will actually loan you some of their machines for you to practice on. And I have plenty of court reporters who are in training, come to my court, and they will take down everything. Of course, it's not official because we have our official court reporter, and they will take down everything. But does anybody have any questions? Now is the time to ask your questions.
May we ask what the determination of the court was in this case?
Yes. So anyway, from reading the police report, anybody objecting to me just telling them what the police. So this entire incident, what ended up happening is the defense's client was involved in a relationship with the complainant's mother. The defendant and complainant were playing some sort of TikTok game. And so the complainant put talcum powder in his hand.
Baby powder? The smell that is. You changing diapers? Damn!
Defendant in the back of the head. And then the defendant pushed the complainant and the complainant hit his head and he ended up with a bruise on his head. So that was the case. And so from reading that, what ended up happening is both parties agreed that he would be sentenced to 18 months in the state jail facility. He has been in custody now. So how much credit will he have?
216 days.
He has about 216 days credit. In this court, I try to make sure that people are not at the jail for long periods of time. But I need to make sure that both sides have their discovery because nobody wants to go to trial and their attorney doesn't have what they need. So in this court, cases do move pretty quickly. So I know 216 days may seem long, but sometimes that has to do with them not being indicted yet. And I don't hear cases for jury trial until they're indicted. But once they're indicted, this court, I think both the state and the defense will tell you this court moves pretty quickly, but also making sure that everyone has their evidence. Any other questions? Yes.
Would it be okay if asked defense they think that was?
Sure. Defense.
We do, yes.
definitely.
He was a habitual offender, meaning a mandatory minimum 25 years in the penitentiary if he was convicted. So we didn't hear that one.
Mhm.
Y'all didn't know that.
That's you,
Yeah.
and you weren't gonna hear that part. And so that we elected to go to the judge for punishment instead. God forbid he was convicted. We had some strategies in terms of hoping to prevent him from being convicted. But yeah, when you're looking at 25 to life and they offer you just a few more months in jail, it's hard to turn that down. So, yeah.
And-
Very.
He's very, very happy, very
His
grateful.
mother has now left. She's an elderly mother. His dad's in the hospital and his mother was in tears. She was very happy because she knew that if he were found guilty and they were minimum 25 years, she would never see him out of custody for the rest of her life. So it was a lot of pressure on us because I built a relationship with the mother as well, who emailed me like 4 times a day, called me all the time. She's a friend of the office now, Daisy. So yes, we consider it a win. Thank you. But thank you for your time. Thank you all of y'all for participating yesterday. I know it was really hot in the other courtroom. So I really appreciate your time and your interacting and your answers and your honesty and all that.
And I will tell you, a lot of cases when somebody is indicted and they are a repeater or habitual because maybe they've been to prison before, normally you're not allowed to hear that because you're not really supposed to base whether somebody's guilty or not guilty on their history. You're supposed to look at this case and see what you would do with this specific case. And then afterwards, if they're found guilty, then you can look at the history and make a determination on punishment. Any other questions? Now is the time.
He was 9 at the time and he's now 11. 9-year-old boy.
And I did have the mother to come in so I could speak to her.
Was she happy with?
She did not want this case to go forward. Yes.
I'm sorry. Because of the fact that he was a boy, 9 years old, did that take any, in your minds, the demographics of us versus a girl, 9-year-old girl?
Well, and I tried to address that a little bit in jury selection, not the demographics at all, but I know that, you know, he had a 2-month-old little girl. So obviously I was trying to make a point, like, obviously if you heard his 2-month-old little girl, that's going to be much more egregious than a 9-year-old boy who's 5 feet tall, you know? So I was trying to make that point and talk about your cases first. It's any child, this charge is any child under 14. So we did look if y'all had children or grandchildren on your juror cards and things like that. So yeah. The baby powder slap challenge.
Apparently that's it. You just put the powder on your hand and you slap somebody, I guess, and that's the whole thing.
And just FYI, the 9-year-old, he was a big 9-year-old. He was not like a
Right.
tiny little kid. I mean, he was a pretty good sized kid, quite frankly. So, yeah.
So just curious. I mean, for 2 years we've utilized the legal system and came up to this. Would there have been a way to get this resolved much sooner without having to involve all these resources?
Isn't that a good
What I can tell you. All right. So I've been on both sides before. I've been a defense attorney and a prosecutor. When you think about it, the DA's office has hundreds, if not thousands of cases. And defense attorneys, it's not like The Good Wife, where you represent one client and that client is paying you $500,000. Usually you have a lot of clients to represent. And so sometimes you have cases that are on the front burner because you know this is specially set, it's going to trial, and you can't be present for 40 people at the same time. So sometimes it's, okay, this is now up, let's get this going. Now, what I can tell you is, as a prosecutor, sometimes when you're getting ready to indict a case, hopefully you look at everything and investigate it. But the problem with that is the prosecutors who are in this court, they didn't indict this case. Somebody else did. And when cases are indicted upstairs, they don't get to say, oh, this is the case I want that's been indicted. It's just random and on a rotation what case they have the case has already been indicted and they have to make decisions. And they're hoping that people have talked to the people that they needed to talk to, because you're not trying to reinvent the wheel.
Thank you.
Sure.
No, I know the defense was, you say you guys were happy with the judgment. How does the state feel about it?
I feel like it's fair, given the circumstances around the case. We were initially asking for a much higher deal, but push comes to shove, I think it ended up being fair for both sides.
Back to the timing and a bunch of factors. We just inherited this case from another attorney on March 28th of this year. So we haven't represented Mr. Reyes the whole 2 years. The off-run date was September 5th of 21. We've only been on it since March 28th of 23.
And since the defendant's mother did not want to move forward, was it the kid that wanted to keep pushing? So,
Yeah, so at the end of the day, it's really ours, and it's our decision at the end. So we figured that we had enough to move forward, even with their feelings. She still showed up today, but at the end of the day, I feel like it came to a fair outcome.
So it's not the father of the child.
It is not the father of the child.
And just so both parties know, so I used to do child protective services cases as well. And I've informed their client and I've informed this mother that part of my ruling is he's not to have any contact with her or the child. So he's not going to have any contact with them, and that's in the order.
And
Yes.
if he crosses the line, is that automatic?
Now, what will happen is if he has contact with her after he's served his sentence and Child Protective Services gets involved, they will see that I issued a no contact order and things will be done on the civil side. And that can happen if her parents were to call, because sometimes you have cases where people call the police and then the police get involved, and there are cases that come to court and then the people involved are saying, well, I don't want charges pressed. I want to withdraw that, which you're not allowed to do. So in this case, you have grandmothers, grandparents on either side who are looking out for the best interests of the children. So I know that if something were to happen where he to show up at her home or she would have called him to show up, somebody would end up calling Child Protective Services, and they would see that there is an order from this court that there is to be no contact. And there's also an order from CPS court already that there is to be no contact.
And obviously, if he didn't have the criminal history that he had, we would definitely be going to trial. We think we could have, well, there's a good chance we could have won this trial, but when the stakes are so high and they offer a client something, and ultimately it's the client's decision whether or not to take, but he's thinking, okay, I can be out in a few months versus potentially 25-year minimum. You can understand so why a client would agree to something like that. So, and that's the unfortunate reality. And having known the judge and I went to law school together, and we've been friends for a long time. And having been on both sides, I used to be a prosecutor myself. I've never been a judge, but when you have these scenarios, it's and for you guys who aren't involved in the meat and potatoes of it every day sort of thing, it's like, oh, well, why would that guy take 13 months in the penitentiary for something that juries, sometimes you can't predict what they're going to do. And we loved all of you guys yesterday. That's why you ended up on the jury. I think we were all very satisfied with all the jurors that we ended up with. But let me tell you, I've tried over 150 jury trials, both as a prosecutor and a defense attorney. I've won trials I never should have won. I've lost trials I never should have lost on both sides. And you just can never predict it. And so again, when someone who's served time in prison before and stuff like that says, oh, wait, a few more months and I'm out and I'm done. Yeah. So.
And he had his intro ready yesterday. He would never get to deliver
it. What's that?
Remember you stopped him yesterday from giving his intro?
Yes.
Oh, yes.
Yes. Yes.
Well, yeah, he has a lot to say.
Yes. Yes.
Sorry, Judge.
Testify.
Yeah, you weren't there, but when we just said, good afternoon, this is our name, and he stood up and he said, I just want to think he was going to go, and we're like, no.
Please, now's not the time.
No statements,
Yeah.
sir.
definitely know now in the future that if you speak up, you're gonna get chosen something.
Yeah. No, usually I will tell you, usually the
Normally the
rules.
opposite. Yeah.
It's the opposite usually. I always tell people if you are very quiet, what ends up happening, and this only happens in this world, it doesn't happen outside of the legal system. What usually ends up happening, you're sitting with someone and you're trying to take notes on everybody to see who you think would be a good fit for the jury. And what it never fails, what it comes down to, somebody will say, wait a minute, do you have anything? Did juror number 5 say anything? No, I don't have anything. Do you have anything? Well, 6 said this. I guess we'll go with the person we don't know anything about. And that's what usually ends up happening. So I always tell people, if you're quiet, 9 times out of 10, you're going to be on the jury.
There are a couple of people on this jury right now that didn't say anything. So
Okay, who didn't say anything?
Yeah.
You see, so all the people, you know what, everybody, everybody who didn't say anything, raise your hand. Okay, so the only people, if you count the numbers, 1, 2, 3, 4, about 5 people said something. The rest of you all are there because you said nothing. But I will tell you this, you're like, yeah.
Can I ask?
Sure.
You like the one that speak?
Well, so we get reason, each side gets 10 people that they can strike for any reason. We don't like their haircut. We don't like, whatever. We don't like the way they look at our client, whatever. So sometimes it's not a matter of we like someone, it's we got to get rid of someone else. And you can imagine from our perspective, there are a few people that raised their hands that we could not have on the jury.
Well,
So, yeah, they would not have been open-minded about our client. So.
And then in this court, the reason why there are 14 of you, I always have 2 alternates because you never know what's going to happen during a trial. We've had some people who've been on our panel and sadly, there's been a death in the family or something else happened. And that's why we have alternates, so we can always move someone else into the seat. Any other questions
So
for the silent people?
sorry.
Go ahead. No, we're here for you.
You were a silent one. Was your selection based anything off of previous, like you knew where we work, you knew like our background, or was most of it done just from kind of?
It's kind of taken as like a whole package. Like we look at your answers, what you said when we were asking you questions, when we were all talking, and then we go back when we're going through and trying to see who we want to get rid of, who we want to keep. We'll then look like, oh, well, she works in this field or she has 5 kids. So you kind of take the whole package into effect and you eliminate or select people based on everything.
Mhm.
But kind of like John said, it's more who we didn't want
Yeah.
on our jury. And then y'all didn't say anything offensive. to us,
And we don't
essentially.
actually get to select, even though it's called jury selection, it's really jury elimination.
Right.
We don't actually get to say, hey, I like what he said. I like what he said. I like what she
We
said type stuff.
eliminate, yeah.
We're only eliminating people, and the people that haven't been eliminated are the ones that end up on the jury. So.
Any other questions? Now is the time. You have great legal minds here.
Thank you,
wouldn't have had him
guys.
testify, right?
What's that?
You wouldn't have had him testify.
Our client, no.
I would have put him in a headlock and prevented him from touching that. It would have been an ugly scene, but I would have done it. So it's like, you are not testifying.
Ultimately, it's their decision. We
Mhm.
can strategize about everything and we can advise him not to. Some clients are stubborn, but I think that he was on board with not testifying.
I've tried approximately 100 trials as a defense attorney and never once has my client testified. And I've won a lot of trials. So it's never, as a prosecutor, you learn that when the defendant testifies, if the case is here, the best you can hope for is the case is still here after he testifies. It normally gets a lot worse for you after, no matter how educated, no matter how smart, no matter how truthful the person is. These guys are paid to poke holes in the story and make them, look stupid or like liars or whatever sort of thing. And that's what I used to do as a prosecutor. She used to do as a prosecutor. And so, yeah, but testifying is essentially never a good idea.
And it's scary too to testify. Because if you think about it, you're up there, everybody's looking at you, judging you. And in your mind, probably as a defendant, you're thinking, oh my gosh, I hope I don't say anything wrong. And what are they thinking? And it's the same thing when complainants or victims testify. All of these things are probably racing through your head. And so it's very difficult. It's not easy. and you're in the hot seat and you're the only person up there and people are firing questions at you. Any other questions?
Thank you guys.
Sure,
very
the
much.
quiet
Yeah,
people.
Thank you.
Well, here are your final instructions. One, you have a sheet of paper. That sheet of paper signifies that you served on a jury today. So you can do one or two things with that. You can donate the money that you're going to receive. And they have different organizations there. I always say CASA because it's for children, but there are plenty of other organizations you can donate it to if you wish. Otherwise, what will end up happening is you will receive a check in the mail, probably 2 or 3 months from now. And you will think, was this a scam? What happened? What is this? Is this a real check? Then you're going to remember the great time you had here in the 187, the great time with both attorneys. And you're going to say, oh, this is real. But seriously, when you receive the check, if you decide to receive it, you can always come back downtown, enjoy some time on the Riverwalk. It'll probably be enough money for at least for you to get, what's the name of my favorite thing? I can't pronounce it. Yes, I had that for the first time about 3 weeks ago. And I'm like, where has this been hiding all my life? It is so good. Deputy Laura will probably be able to direct you to the place that's around the corner. They have one called Texas Rose that has cucumbers and green chamoy and pickles. That's not my favorite. My favorite one is the regular one. Yes. So it's very good. They're trying to take me through the foods of San Antonio. I've been here since 1997 for law school.
94.
I mean permanently, John. Permanently.
She went straight from 3rd grade to law school. So she is quite a bit younger than I am. However,
But there are certain foods that I'd never had until recently. One of them was tamales. I think I hadn't eaten those though, because there was a fear involved. Because you see it, am I supposed to eat this wrap? What's going on here? But then once I learned how to eat it, I was bean and cheese. Where have you been all my life? It was just fabulous. So they're taking me, I had my first corn in the cup, a cup corn or whatever it's called. So they're taking me through my tasting.
Tell them.
Yes, I had churros for the first
Tell
time.
them where you're from, Judge.
All right. So I'm originally from Louisiana. So, I see somebody saying, oh, is that a good O?
I mean, I'm from Georgia, so it's a southern thing, and I know Louisiana a little.
Well, guess what? You're not going to be doing well in the SEC this season.
Back to back.
No, my other friend, Cornelius Cox, he is a Florida Gator. So LSU, of course, we're playing them later in the season, and we always bet a lunch on the game. And he's like, as long as we're not playing LSU at night and the game is close, we'll win because the refs will take it from you at night. I said, whatever. So we will see how we do. LSU has been doing great. Baseball.
Yeah.
Track and field.
Yeah. They've won everything.
Yeah. So basketball. If only we can get our men's basketball team to do something. They didn't even do anything with Shaquille O'Neal.
No,
Les Miles and his freak defense.
They
Yes.
didn't.
So Georgia Texas is coming to see.
Oh, well, you know what? I'm going to see. I'm going to tell you what I told A&M. A&M came to the SEC because they were not being treated right. And I told them, look, SEC, we're family. We're going to beat you on Saturday, but we'll still invite you to the cookout. So Texas, you want to come? We're going to beat up on you, but we'll still invite you to the cookout.